and I will read your bio and we will get started. All right. So, hello, everyone. Today we have a special guest, a very special guest, Arlene Marcial, who is the founder and the CEO of Wills and More. She is a 50,000 ring earner and is the 2023 Ladies of Justice Awards winner for both recruiting and also production. She has been a Legal Shield independent associate for over 20 years. Wills and More offers many platforms for families to get their estate planning documents prepared so they can leave legacies instead of mysteries. The services provided through Legal Shield is one platform offered to simply afford families and small business owners with a legal team, including but not limited to unlimited consultation, contract and document review, estate planning documents, special needs trusts, are available for an additional fee. Simply put, she simplifies and demystifies the business legal needs of entrepreneurs, estate planning, and identity theft protection services, all through Legal Shield's nationwide network of attorneys. Eileen has Eileen has been married to her college sweetheart for over 38 years and is the proud mother of two granddaughters, proud grandma to Angela and Naomi, and as a longtime member of First Baptist Church of Lincoln Gardens in Somerset, New Jersey, and lives by her motto, NBGG, nothing but God's grace. So without further ado, Eileen, I will let you take it away. And
Yes,
you
I
are
was
on mute.
muted because
Okay.
my dog started barking and I didn't want
Okay.
y'all to hear him complaining about someone outside. So, thank you for that amazing introduction. Thank you so very much for inviting me to share some information with your team today. I am Eileen Marcial. I am the founder and CEO of Wills and More, and I'm a girl mom. Yes, I have two grown daughters, two granddaughters, one husband, and two male dogs. That's my crew. That's how we roll here in New Jersey. But I just love being able to simplify and demystify the estate planning process because less than 30% of all families have something in place, and we're able to level that playing field so legacies could be left instead of mysteries. So I'm honored to be here, honored to share this information because the main thing is you have to change the narrative. Less than 30% of all families have a love letter will package in place. It should be our mission to move that number from less than 30% to 50%, one family, one client, one church at a time. So the information I'm about to share with you, I do every Sunday at 3 o'clock, but I just wanted to make sure that you knew what we do so you can get this in front of your folks so we could close that gap from 30 to 50. So without further ado, I'm going to share with you how to leave a lasting love letter to your family. I'm going to share my screen. And this is a presentation I do every Sunday. I've done oh my goodness, over 800 to 1,000 of these since the pandemic. We've been blessed to assist on over 700 love letter will packages since the pandemic. And we called it a love letter will package instead of a will, because a lot of folks really, really, really don't take to the word will well. They feel it's going to be doom and gloom and that they're going to die. But when you really look at it, no one leaves here alive. So let's leave a lasting love letter to your family. So we're going to talk about estate planning, which is the basics. Everyone has an estate to plan, whether you do it yourself or you let the state do it for you. It's better to do it in the former. You figure out what you want your family to have. So really, there's a huge problem. And that problem is easily solved. The problem is, why don't most people have a will? So if you have your will presently, please put in the chat, will, right? So that we have an idea who we're working with, right? But the thing is that I throw myself under the bus every Sunday because it took me 6 years to complete a 6-page document, which would have afforded my family the peace of mind of a legacy instead of a mystery. But most people don't have a will because of procrastination, and I led the list of that. It took, as I said, it took me 6 years. And something happened that scared me so much that I filled out those forms and we have redone our will no less than 10 times since that first time, almost 20 years ago. Procrastination is usually a result of not knowing what needs to be done. right? And so what we do with these seminars, what you're going to be empowered to do with your clients, your family, your churches, is that we're going to simplify and demystify the process so people aren't one, priced out of it, two, not afraid of it. So we're going to take procrastination off the table. Secondarily, people feel they don't need one, and maybe you don't. But if you have a bank account, you have a child, you have a pet, you have a loved one, you need more than just a will. That's why it's a package. You get the will, living will, healthcare power of attorney, financial power of attorney, and the ever so important minus trust. If you need a basic revocable will, we can get that for you, as well as special needs trust. So if you feel you don't need one, consider the whole package, not just the will. And when you think about expense, right off the break, you can easily pay $600 to $2,000 for a will. So I have a dear friend. He's a real estate attorney by trade, but he does estate planning also. So when I told him what we do, he's like, "Oh, there's no way you could do it for that price point." So I asked him to come take a look, and he did. And he said, "Oh my God, you're more thorough than we are." So he sends all his referrals to me. But in November of 2023, he called me and he said, "Look, Eileen, I need you all to do my will for me." So this man that charges $1,200 to $1,500 for one will got his will done for $360 through our service, will, living will, healthcare, the whole love letter will package. So we take expense off the table. So the Legal Shield plan is most definitely the solution for leaving a lasting love letter for your family. So let's talk about your estate. Your estate is all of the assets, all of the stuff you've accumulated. Do you have real estate? What do you want to have happen with it? Bank accounts, investments, personal property. Personal property is where most of the family disagreements occur. Well, mama said I get this. Well, daddy says I get that. But if it's not in writing, it's going to be a money grab, a jewelry grab, a car grab. So put it in writing so people aren't fighting. Now, if you're a business owner, please put biz in the chat. If you're a business owner, you want to make sure your business doesn't die with you. So you need to have a conversation with someone like y'all, right? They can actually show somebody what they need to do for key person insurance. Financial planners to let you know what you need to do to keep that business solvent. An attorney to answer those questions too, basically a legal team, right? So you're able to have that discussion about that big piece of your estate. And what do you have? Do you have life insurance, LLC, retirement plans? That all comprises your estate, what you've built and what you're leaving behind. So there are three goals to estate planning. The first one is to manage your affairs during your lifetime. Those are powers of attorney. You have the medical/healthcare power of attorney, which you decide who you want to speak with the doctors in the event you're no longer able to. It's not a popularity contest. In the same token, if you're not able to handle your finances, who do you want to do that for you? The financial power of attorney comes in two forms. The first one is the durable financial power of attorney. That happens immediately. As soon as that document is notarized, whoever you designated as your trustee has access and dominance over your finances. So our attorneys err on the side of caution. They don't just automatically send out a durable financial power of attorney, which is usually reserved for someone of diminished capacity. The second one is the springing financial power of attorney. That springs into effect when you are no longer able to make your own decisions and a doctor deems that to be so. So we send that out so no one has power over your finances. But you need to have those in place because if you don't, then the courts get involved and they don't know the family dynamics. So the medical power of attorney and financial power of attorney and living will die when you die. So now that you're gone, you need an executor, executrix who's going to distribute your assets or your estate after you're no longer here. This is something you must choose wisely because the person or persons you select are going to be subjected to the onslaught of people who feel entitled to your stuff, right? So you want to make sure you pick the person who's going to be able to handle that, right? So, but doing step one and step two minimizes problems for your family. And this is a love letter, right? And that's why we want to simplify and demystify it for your family. So there are three challenges to estate planning. I'm a huge sports fan, right? So even back to the Olympics with the women's gymnastics, basketball games, football games, baseball games. I don't know about hockey, but there's always a challenge, right? So I'm a big fan of Michelle Obama's, and she's a box checker. And so we're going to check these boxes. Finding the right attorney, we can check that box because through Legal Shield, we have esteemed estate planning attorneys in every state. I'm blessed to live in the state of New Jersey. Our estate planning attorney, who is the esteemed George Weinroth, has been doing estate planning for over 50 years. He stays current, he knows his stuff. So you don't have to go and find the right attorney, family. You can just pick up the phone and know that you're going to get a top of the line estate planning attorney. Now, you could go through an old dusty yellow pages to find an attorney, or you could do a Google search, or you could drive down the road and see a sign on the road that says estate planning attorneys, but you don't have to do that if you have these services. So finding the right attorney, check that box. Getting it done, I love doing this presentation because we simplify and demystify the process. It took me 6 years to go through 6 pages. If someone had taken me through this process, it would have been done in 6 days or 6 hours. So we can check the box of getting it done. And then choosing the right options. I don't know if I mentioned this before, but let me make it abundantly clear. I, Eileen Michelle Marcial, am not an attorney. I don't pretend to be one on TV or anywhere else. However, I've been blessed to work with attorneys nationwide and helped over hundreds of people to get their love letter will package done by that same 6 page document that took me 6 years to complete. So if you need a trust, please don't fall prey to the folks who say that everybody needs a trust. Have an articulate conversation with an estate planning attorney who sees your assets, which is page 6 of the document I'm going to take you through, so you can find out what trust, if any, is going to make sure your estate is handled the way you want it. So choosing the right options, you speak with someone who can address those, and especially in your jurisdiction. So let's talk about estate planning options and terminology. So dying intestate means you had no plan at all. Your plan was the state's plan, right? So the person who comes to mind, and I've thrown this woman under the bus religiously since she passed away, is the late great Queen of Soul. Aretha Franklin was one of the most fabulously dressed person in the casket I've ever seen. I didn't see Liberace, but my girl had on a gold lame gown and Louboutin shoes and nowhere to go. I understand they changed her clothes twice in the casket. But for all intents and purposes, family, there appeared that she did not have an estate plan in place, even though she had such a dire prognosis. So her sons it was total disarray and chaos between her sons until it was discovered that she had two wills. They were handwritten wills, which are called holographic wills, and they're the easiest ones to contest. So what happened is they found one in an obscure cabinet and the other one in the cushions of the couch. And she didn't have good handwriting, family, so it took a minute for them to figure out which one they were going to honor. So a few years ago, they finally, after a big kerfuffle at the surrogate's court in Michigan, they determined that the 2014 will was the one they were going to adhere to. So now there was peace and no more chaos amongst her four sons. Please let's not leave our family to that kind of disarray. Let's get this done. Let's leave the legacy instead of the mystery. Powers of attorney I touched on already, but just so you know, without powers of attorney, we are going to prepare the medical power of attorney and financial power of attorney, either durable or springing, for you, your significant other, and any never married children between the ages of 18 and 26. Those ages are very important because in most states, a parent is no longer able to speak to the doctors of an 18-year-old or older because we don't have that form. So the medical power of attorney puts the ball back in your court so that you can do what you need to do. So what I do is I tell everyone that once you have that medical power of attorney and financial power of attorney notarized, then you want to make sure the person you designated has it in their phone, right? Technology is amazing. You can scan it and have it there. Back in the day, you used to run home, find the folder, and take it to the hospital. Now you can tell the doctor if you get that call, doctor, I have the medical power of attorney, the living will, and the financial power of attorney. Do you want me to email it to you, text it to you, or fax it to you? That puts the ball back in your court and lessens the panic so you know that you can discuss what's going on with your loved one if you get that dreaded phone call. So, healthcare directives, what do you want done at the end of life? Do you want to be do you want to have a feeding tube? Do you want to be plugged into a ventilator? Do you want to leave your body to science? I'll tell you what, if the latter is true, I definitely am looking to convince you that you do your due diligence while you can. Because I know that if I tell my family, I leave it in my notes that, yeah, please donate my body to science, and I didn't tell them how, they will drop me in a hole somewhere and put a tombstone to say where I lay. So, if you're going to do something like that, please find out what needs to be done so that takes the stress off of your family. Beneficiary designations are ever so important because they're often overlooked. Y'all are insurance agents, you know what can happen if somebody's dead, not in their good graces, or has lost their mind. So those are the three criteria we use. When you check to make sure your beneficiaries are still the people you want to benefit from what you're leaving behind. You want to make sure, one, they're alive. Two, they're still in your good graces, or three, still in their right mind. So alive. My dad had my mom still listed as a beneficiary, and she predeceased him by 5 years. Thank God I was on this, so it wasn't a problem. Let me share a story with you. This is just crazy. One of my best friends, her niece passed away unexpectedly in her mid-40s. She had been living with a guy. They broke up, he moved on, but she passed away before she could take him off as a beneficiary. So when she died, this guy got $60,000 of her insurance proceeds that could have gone to her family. So you need to check these things out every year just to make sure that is the truth. And dementia and Alzheimer's is snatching up our family at a record pace of families. So let's make sure alive, still in your good graces, still in their right mind. All right. So jointly held assets, as I told you, I'm not an attorney, but we have attorneys in every state. If you have property, how do you want it distributed? Do you live in a state where you can have a transfer on death deed? So that's something you discuss with the law firm. These are the things you need to discuss so that our family properties end up derelict and just total messes or gone sheriff sales because it wasn't in writing what you wanted to have happen. This takes care of that for you. The will, I'm going to go in depth on, but let's talk about trusts. Trusts are amazing. Yes, they can avoid probate, but the thing is, you need to have something to fund the trust, which means you have to have something to put in a trust. Not just because Susie Orman, Dave Ramsey, or some clown on TikTok said everybody needs a trust. No, you need a trust if you have something to put into a trust. And so what I love about our services is that when we get to page 6 of the document I'm about to take you through, that's your assets and liability page. That's a snapshot of your net worth and what you have as assets. So then you can have that articulate conversation with the law firm. Do I need a revocable trust? Do I need an irrevocable trust? Do I need any of the other plethora of trusts that are out there? Don't get hoodwinked because somebody just that doesn't know what you have or your circumstances is telling you what you need without any facts, right? So trusts are available for an additional fee, and definitely there's a revocable one you can get for $250 at the discretion of the law firm at the determination of what constitutes a basic revocable trust. All right, so let's talk about where the magic happens. Okay, this is the will questionnaire. This is page 1 of the 6-page document that took me 6 years to complete. Yeah, I'll throw myself under the bus regularly because once I got it right, we are always straight, right? But let me take you through this because people get intimidated, just as I had been. So basic information, what's your full name? That's easy, right? If you're a lady, what were your other names? What was your maiden name? I had a lady, she was married 5 times. She married one guy twice, and it didn't work out either time, but all 5 names needed to be there. The membership number comes with the right and privilege of using Legal Shield as your platform to provide your love letter will package for your family. What's your date of birth? Be honest. There was a comedian back in the day. His name was Jack Benny, and he would always say he was forever 39. Newsflash. If you're forever any one particular age, that means you have died. You don't want to be in that group. So put the right age down. Are you a citizen? If not, where are you from? Please put that in the chat also. And where do you live? Question 3 gets a little sticky sometimes. If you're married and everything's cool, write married and put your information for your spouse there. If you're separated, write separated, but please include your current spouse because you're still married to them. If you're divorced, write divorced. If you're widowed, please accept my deepest condolences and write widowed. Question 4 is one of my favorites. On April 11th, next month, is the 44th anniversary of my husband and I, our first date at the University of Virginia. We've been married for 39 years. It will be 39 years in August. When we got married, we didn't have 3 nickels to rub together. We were broker than 3 jokes. We came back from our honeymoon ripping open envelopes so we could pay our rent. So our prenuptial agreement to each other was that we would do better. But on real talk, if you are getting married and you have your own set of assets, please speak with the law firm about getting that prenuptial agreement in place because that gives you the power of saying where you want the asset you bring into the marriage to go. Shouldn't be community property unless you want it to be. All right, so that's page 1. Page 2, have you or your spouse ever been divorced? And if so, when did you marry husband number 1 for the ladies? When did you marry your first was gentlemen? If there was more than one, 1, 2, 3, 4, 5, when did you marry them? When did you divorce them? And what court rendered the decision? So one of my earlier clients was one of the proudest divorcees I'd ever met. She said, as soon as I met her, I'm divorced. I'm like, okay. I said, fine. So we get to this question. So I asked her, when did she get married? And she said, girl, I don't remember. It was the worst day of my life. I don't remember. So I said, okay, no problem. How old were you? So we surmised she got married in the summer of 1972. When we got to the date, the divorce information, she got colorful. She said, girl, my hair is flawless. I had an amazing red pantsuit on. It was a beautiful Wednesday afternoon around 2:30. She remembered all the details of the divorce, but nothing about the wedding. But then the court rendering decision and all that good stuff. Filled it out. We were good. Question 6, have you or your spouse created any trust or made gifts to trusts to others? That's usually a special needs trust family. And I have a family where the couple was in their 80s, their son was severely autistic, and he was in his 50s. Their concern was what would happen to their son when they made their transition. So I introduced them to the esteemed George Weinroth, and he created what's called a special needs trust. So when they make their transition, everything they're leaving to their son is in a trust that cannot be attached by the state with a lien, and they cannot take away his Social Security benefits. This is something you definitely want to address if you have anyone in your life that has diminished capacity, mentally or physically disabled, or has special needs. Question 7, do you expect an inheritance? If you do, say yes. If you know what it is, write it down. If you don't know or to be determined, write no or to be determined. Easy, right? So far, so good. So now let's talk about your children. If you have children, including adopted children, we need their full name, whether they're a son or daughter, and their date of birth. Son or daughter is important because in the event that they have a unisex name, we need to know if they're a male or female, right? So you feel that if you got more than 4, just use a separate piece of paper. And question 9A and 9B, I always preface with please accept my deepest condolences. Because if you have a child or children who passed away, we need to know whether they were your son or daughter and when they passed away and what their children's names are so they can be included in the distribution. I can't imagine the depth of the pain of losing a child. So if you have, please accept my deepest condolences. So now, I used to have so much fun with this question. I used to sing the Brady Bunch theme song and everything, but blended families are serious business. You may have a blended family and everyone it's such a beautiful blend that you can't tell who you gave birth to or who you didn't. But the thing is this, if you want those children to be included in your distribution, they need to be included in your will. If you don't, if you want somebody excluded, we have something called disinheritance that we'll talk about in a moment. But grandchildren is one of my favorite things. I'm a grandma, I told you that at the beginning. And there are two trains of thought. The first one is God bless the child who has their own. And that's what my husband and I believe. When our first granddaughter was born 3 years ago, we changed our will. So she gets her portion of the distribution. When our second one was born 6 months ago, same thing, right? But if I have friends that have 30, 40 grandchildren, I can't even imagine that, right? But in any case, if you have that many, it's perfectly fine to say that my children will make sure that their children get their portion, right? And then 12 goes back to the special needs trust. And please list who your family members are with the special needs so that you can have that conversation with your local George Weinroth to get this taken care of. Questions 13 and 14 comprise what's called the minor's testamentary trust. I just call it the minor's trust because if I could cut down on syllables, I always do. But question 13 asks, who do you want to raise your child or children in the event that you or their other parent are no longer here? It's not a popularity contest. You want to pick the person who's going to raise your child or children the way you would have raised them if you were still here. So I have a story for this. One of my best friends, her best friend had stage 4 breast and lung cancer and a 12-year-old daughter who had never met her dad. So my friend was taking care of her friend and they put her on at-home hospice. And I called my friend and I said, will you tell your friend that when she makes her transition, her daughter's going to Brooklyn to live with a man she never met. 10 minutes later, not even quite 10 minutes, I got a phone call from the weakest voice I'd ever heard, asking where could she meet me. I live in Somerset, New Jersey. She lived in Willingboro, which was about an hour drive. This 6-page document I'm going through with you, I took with me. I filled it out and sat on the floor. She was too weak to sit up. She signed it. I took it to the law firm and I said, time is of the essence. There's a 12-year-old in the balance who has not met her dad. I went back. A day and a half later, picked up the will, living will, healthcare power of attorney, financial power of attorney, and the ever so important minor's trust. So that young lady is now 23 years old. She graduated from college last May, cum laude, in the degree of her choice from the college of her choice, living in the home her mom wanted her to. But for the fact that this was in writing. But I want to caution you. There are going to be folks that may try to coerce you, as somebody tried to coerce this poor woman, into having them take care of your children or grandchildren for that matter, because they want the Social Security benefits. Think long, think hard, think right, because we don't want to leave our children to an uncertain future. So now, the guardian was taken care of. Now, if by chance the person you have raising your child or children is horrible with money, you need to say, no, I don't want them to be the guardian of the money or the conservator. You're going to pick 2 other people to do that. So at what age? They have to be at least 18. I've seen as high as 55. But choose wisely. With question 13 and 14, if you are a grandparent, this is ever so important that the person or persons that made you a grandparent have this in place. Because if not, there can be some tussles amongst the grandparents. Hey, my daughter and son-in-law already know that it's in writing because I don't want to have to go, get into trouble, going to task with the other grandmother. The girls are mine. No ifs, ands, buts, or maybe they're mine. So this way, you can alleviate problems amongst the grandparents. All right, asset allocation. I'm a closet teacher, so there's way too many words on this page, right? So option A, are you married? Do you have children? If your spouse is alive, it goes to your spouse. If you have children, it goes to your children in equal shares. If one or more of your children predeceases you, their share goes to their children in equal shares. If there's no one left of your heirs, then you use those lines to say, yes, I wanted to go to this charity, my fraternity, my sorority, my church, wherever you wanted to go. So that's option A. Option B is the same as option A without a spouse. I'm unmarried with children. I want my assets to go to my children in equal shares. If one or more of my children predeceases me, that child's share goes to their children, unless otherwise noted, because this is your will. And once again, if everyone's all gone, where do you want it to go? But since the pandemic and helping over 500 of folks with a purple pen on this paper application, because I am a dinosaur, option C has been the favorite. because this way you get to freestyle. You get to say, hey, I want my red car to go here, my blue car to go there, my Rolexes to go here, this house to be sold. However you want, you can freestyle and be as exact as you want in option C. Okay, so disinheritance, I mentioned that before. If there's somebody you do not want to get anything, you can honestly disinherit them, but please speak with your local law firm to make sure it's done correctly so it sticks. All right, healthcare power of attorney. I touched on this before, but question 17 also is for the financial power of attorney. In the event that the person that you want handling your healthcare isn't the same that you want handling your finances. So being the dinosaur I am, take a purple pen, asterisk, and write financial power of attorney and the person or persons you've selected to be that. But this document, as I said before, we will create for you, your significant other, and your children between the ages of 18 and 26. And the question needs to be asked, do you want them to act on your behalf immediately or only when a doctor says you're no longer able to? And once this document is completed and notarized, as I said before, make sure that the person you designated has it in their phone so they don't have to go scrambling to find the paperwork. You can have them say that I can email it to you, fax it to you, or text it to you. So the ball remains in your family's court. Okay, so the executor, executrix, that's if you get this done. Who do you want to make sure that your assets get distributed the way you want them to be? If you're married and everything's cool with your spouse, you check yes. If you're married and things aren't cool with your spouse, you check no and pick two alternates. If you have no spouse, you pick two alternates. It is not a popularity contest. It's a rather difficult job in some cases. So as I said before, you want to make sure you pick the person who has the strongest intestinal fortitude to be able to withstand the onslaught of people who feel entitled to your assets, right? And so that's the person that's going to go to the courthouse, go to the surrogate's court to get the letters of testamentary so they can go about distributing your assets. And when it comes to the fiduciary bond, most often you're going to waive it because you're picking a friend or a family member. But if you pick someone like y'all, insurance agents, brokers, financial planners, accountants, doctors, lawyers, they have a financial responsibility to your estate. So you're not going to waive the fiduciary bond. They need to be bonded. And if you don't get this done, you're going to have an administrator instead of an executor or executrix. I had to share this really sad story. I was out minding my own business one day last week when one of my colleagues called and said, I need you to speak to this woman. I said, well, what's going on? Her sister is 34 years old. She had a 4-year-old and an 8-year-old son. She wasn't feeling right, and she kept going to the doctors and sounded like she had MS from what they were telling me. But every time she went to the doctor, they sent her home. So she went into the hospital, walked in talking, walking, and then they were supposed to do a procedure last Tuesday. Before they could even do the procedure, this 34-year-old young woman died. She was about to do her estate planning documents with one of our colleagues, but suddenly happened, and now they have to go through different routes to make sure that those two little boys are raised in the family with love. So we may think we have so much time, and maybe we do, but on the off chance, let's make sure we get this done and we have our friends, family, colleagues, and clients get it done too. All right, special provisions can be handled under option C, or you can take as many pieces of paper and be as exact as you want to on special provisions. So that brings us to page 6 of the 6-page document that took me 6 years to complete. So the operative word here is estimated. You don't have to go on Zillow. You don't have to go climbing through closets to find old tax documents or anything like that. It's the estimated value of your assets as of today's date. So, do you own your home? Does your spouse own your home? Do you own it together? How much is it worth? Do you have any other real estate? So I just did a will I did a will questionnaire with someone on Saturday. She has 6 properties. Right? So we used a separate piece of paper to denote what she wanted to have happen and how much each was worth. Checking, savings, credit union, your financial institution is all we need. Question number 1, 2, 3, 4, 5. Just get creative on how if you have more than 2. By no means do you want to put your account numbers there. because account numbers are personal identifiable information. And when you die, your will is a public record. You do not want personal identifiable information on your will, right? Which is public record. But on the lines next to the financial institution, I want you to put beneficiary on file, payable on death, or transferable on death, right? And with bank accounts, it's ever so important because if that's not denoted or you don't have a credible or bona fide cosigner, the bank can get cute. One of my friends, her mom passed away unexpectedly like 3 years ago. Her mom was savvy though. Her mom had a will, she had a love letter will package, but she had a payable on death on her bank account. My friend took the death certificate to that bank. They wrote her a cashier's check, certified check for the full amount of what her mom had in the bank because there was a transferable on death on file with the bank. Do you own your car? Cool. What is it? What's it worth? That's an asset. If it is a lease, that's a liability. It needs to go back. Stocks, mutual funds, and other investments, qualified 401ks, and life insurance, beneficiaries on file, payable on death, or transferable on death. And remember the rule of thumb. Check once a year to see if they're alive, still in your good graces, or still in their right mind. If you have a business, please note the name of the business and if you have a succession plan in place. Miscellaneous, for years, I had no idea what to put there. But now you can put timeshare there. Or if you know folks that have a gun collection, we have a gun owner supplement, which gives you the option to have a gun owner's trust so that what you're leaving behind is a legacy in the form of firearms. If one gets away, is used in commission of a crime, that you're not leaving a liability to your family, but you're leaving a legacy in the form of that um, firearms collection. So those are your assets. Your liabilities are what do you owe on your mortgage, on your car? Do you have student loans? Do you have a HELOC? Do you have medical expenses? So bills over $5,000. Whose debts are they? And we total that, right? And you subtract your liabilities from your assets, and that is a snapshot of your net worth. And then you can have that conversation with your local George Weinroth. Here's page 6. Here's all my other stuff I want done. Should I get a basic revocable trust for what I have? Or do I need a revocable trust, an irrevocable trust? What do I need? Have a conversation with someone who can have that articulate conversation, seeing what you have to know what you need to protect that for your legacy. All right, so promise me, you're not going to fall prey to anybody beating their gums about everybody needs a trust. You see the document that took me 6 pages, but page 6 took 6 years to do these 6 pages. And our goal with this is to simplify and demystify it so that it doesn't take you 6 years. It doesn't take you 6 months. Shouldn't even take you 6 weeks. We've been able to get this thing done in 6 days or 6 hours. So let's empower as many people as possible so they can leave a legacy instead of a mystery, memories instead of messes. I have one more thing I want to share with you though before I let y'all go for the day. Back around the pandemic, we felt like, well, our attorneys felt that not everyone has a paper telephone book. So when my dad passed away 15 years ago, Daddy had one of those telephone books that he had written everyone's name in. So I was able to call each person, let them know he had passed away and what the arrangements were. But when I make my transition, I don't have a paper telephone book anymore, right? This is my telephone book. It's a digital asset. Someone needs to know how to get in to my contacts and my passwords. And so somebody needs to be designated to have access to modify, delete, control, and transfer your digital assets. But the question is, what is a digital asset? Okay, so here's an inventory. I was blessed to be on a presentation about a year and a half ago with the estate planning attorney from Fiffick Law Firm in Pennsylvania. And he had this whole grid, but I don't know if I shared with you, I am a card-carrying member of the Dinosaur Society. I don't see well even with glasses sometimes. So I wanted to make sure they were in bullet points so we all could see. So the digital assets are your email accounts. Someone needs to have the password to shut that down because a lot of fraud occurs in dormant or unattended email accounts. Social media, I am not good at it. Don't want to be good at it. I'm perfectly fine where I sit. But the thing is, if you have social media presence on different platforms. Please make sure someone has access to the passwords to those platforms. So well worded, well placed. In memoriam page to be on each platform. It alleviates the creepiness of the Facebook post. Oh, wish so and so happy birthday, and you went to their funeral 6 years ago. This is straight creepy. So we don't want that to happen. So let's make sure somebody has that permission. Virtual currency, I can tell you about crypto. Crypto comes in wallets, and each wallet has a 12 or 24 character phrase or password. If you do not have a beneficiary on file with that wallet, it can die with you because someone needs to be designated to have permission to use your 12 or 24 character password or phrase for your cryptocurrency. So don't let it die with you. Make sure that that's done and updated every year to make sure nothing changed. NFTs, well, I know what NFTs mean, and I also like it's non-fungible token. Still makes no sense. But the thing is that a non-fungible token allows for you to own part of an image. Yay. Still unclear to me, but if you have one, you know who you are. Do you have a 12 or 24 character password for that? And is somebody the beneficiary on file for it? Need to have that discussion. So with digital storage, reward points, online shopping, business services, photos, books, dating apps, gaming, and streaming. They all have passwords. We need to make sure someone has them so they can shut it down for you. All right, so that's the digital asset inventory. So you want to have that conversation to make sure someone's in place. And because of the nature of what we do, we have identity. I have ID Shield, and our ID Shield is one of the most robust services out there. So I'm not going to go into the whole program, but to three that address what we're speaking about today. The password manager is by far my favorite because what it does, it entitles for you to have up to 6 friends or family members listed to be able to have access to your passwords and contacts when you pass away. I've seen the aftermath of the chaos when someone passes away and no one knows how to get into the phone. I have 2 teammates who lost adult daughters and they still can't get into the phone, don't know the bank accounts. So please, let's not leave that chaos. If you don't get it through us, make sure you have a password manager so someone has access to your accounts and your contacts. Additionally, it will help you create hard-to-hack passwords. That comes in handy if you're a dinosaur, right? That's a great feature too. Now, malware is out there, it's alive and kicking, causing many problems because you know, people just want to get to your stuff. We have our own virtual AI platform that will check to make sure that before you click on something, they'll let you know if it's legit or not. It's cloud-based, and it keeps you protected against ever-evolving malware infections. In the virtual private network, I travel a lot. I'm all over the place, and I'm sure some of you are also. The problem is, wherever you see that free Wi-Fi sign, the matter is this. The only thing free about free Wi-Fi is that it gives free access to hackers to your information and your devices. So you want to have protection from risky Wi-Fi networks. So that's just a microcosm of what we do with a very robust program. But the thing is, let me show you where the magic happens, right? So we have 3 different plans. The first plan is basic of all basics. It protects you and your significant other. We will do your will, living will, all that good stuff, but we will not do revisions. And if you drive, you have to wait way longer before we'll represent you for a moving violation. Right? So the plan I'm going to share with you is our sweet spot. It's the preferred plan. It's $37.95 per month, and it protects you, your significant other, and your never married children between ages of 18 and 26. Well, it covers everybody up to the age of 26, but with the will is 18 to 26. And it's unlimited personal legal advice, contracts and documents reviewed up to 25 pages, and letters and phone calls on your behalf. I went over the love letter will package, and to me, this is where it's worth the price of admission. And for what you all do, you're already there, you're already their trusted advisor. So why not share this information, right? And just say, now that we've done this, let's get this done. You get a moving violation, our attorneys go to court with you after 10 days for a $79 court fee. If you get sued, For a civil lawsuit will represent you for a set number of hours that increases every year. And if you get audited by the IRS, we're going to send a tax attorney with you to the audit, but we'll try to resolve it before it gets there. There's 24-hour day access to attorneys if there's an emergency situation. So remember, I told you that um, when people don't have things in writing, there's going to be fighting. So one of my very best friends is a funeral director in Cincinnati, Ohio. And he came to one of these seminars and he said, you know, Eileen, there's a fist fight at my funeral home every week. I'm like, you're kidding me. It's a really nice funeral home as funeral homes go. I've been there. But he says, yeah, nobody has anything in writing, so they get to fighting. Right? So if you find yourself at a public place getting into a fist fight over what you should or should not have because of somebody passed away. No, trust and believe you're gonna get arrested. But before you get into that car, you can have an attorney on speakerphone to know what your rights are. Preferred member discount, if you want to get that trust done, we do it. You need to file bankruptcy, we do that. Need help with child support, we do that for a preferred member discount. We do uncontested divorces, adoptions, separations, and name changes after 90 days at no additional cost other than you paying the filing fee. But for the business owners on the line, those that put biz in the chat, if you live in New Jersey, we have what's called a home business supplement, New Jersey, Massachusetts, and Alaska. It protects up to 5 EIN numbers nationwide for $14.95. Now, if you live outside of those 3 states, don't feel bad. It's still worth the price of admission at $29.95. It protects up to 2 EIN numbers or business interests in your home state. You get 4 business contracts or documents reviewed every month up to 25 pages. If you need additional ones, they're $75. Far too often we sign the contracts and then regret them later. So we review your personal contracts as well as your business contracts. We write letters and make phone calls on behalf of your business. If you get audited by the IRS for your Schedule C or E, we'll represent you. And we do debt collection letters. So price of peace of mind that can protect both sides of your empire is worth it. So if you have business owners that you work with, this is a slam dunk. Right? And so the price of peace of mind and protection can be offset by members' perks. We have affiliations with over 400 companies. Right? So I run in Adidas. My husband wears Ray-Ban. I walk in Reebok. I told you about my sweet granddaughters. So I was able to get their car seats and strollers and booster seat, all that good stuff at a discount. I rent from Enterprise whenever I rent, get good discounts. I got a horror story to share with you, but don't have time for that today. I live in Costco. When I get finished with this call, I'm going to Costco, right? And so we have Costco, we have discounts on cell phones, the devices, accessories, and over 400 different companies, including hotels and things and groceries. But every night I light a Yankee candle in the scent of lavender because I run on a high level of energy and I need to take it down before I go to sleep. So I get a discount on my Yankee candle. So the price of peace of mind and protection can be offset. If you do the preferred plan, it's $37.95 per month. If you want to do the premium plan, it's $49.95 and includes an opportunity to have a basic revocable trust for $250 and simplified probate in the event that we did the will for the person who has passed away. If you want to include our identity theft digital asset protection plan as an individual, you're looking at $57.90 per month. For the family, it's $84.90. And let me just remind you that the basic plan only covers the member and their spouse, and there's no revisions allowed. So that's the presentation. So I'm going to stop sharing because the call to action is I'm talking to professionals here, insurance professionals, and I'm honored to be doing that. I'm working with an amazing team in San Antonio that just have gotten this down to a science because you're the trusted advisor. So what we want you to do is if you're interested in learning more on how you can offer this as a value add, or even if you said in the chat you don't have your will, start with yourself. But let's get this done. I do this seminar every Sunday at 3 p.m. Eastern Standard Time. I don't mind. We'll do this again because I know some folks weren't able to join us today. But Charles, thank you so very much for allowing me to be here. I'll put my information in the chat.
All right, thank you so much. So I don't know if we still have a few minutes left. I don't know if anyone has any questions. I mean, you could raise your hand. You can come off mute. Um, I can tell you, I don't know if a lot of people on the team know this story, but why I was so passionate about this service and offering them to my clients is because my dad had passed a few years ago, right? And you talk about the blended family, like he divorced my mom and he got remarried. He moved to Georgia, and apparently he got into the buying selling homes business, down there. So when he passed, he had several homes in Georgia. He had one property in South Carolina, so he remarried. And his thing was he didn't care about the property in Georgia, but he definitely wanted to make sure the property in South Carolina went to myself and my brother. And also there was a boat, it was in Myrtle Beach. Like I had plans, like, yeah. But when he passed, he didn't write it down. He didn't have a will. And as smart as he was. And guess what happened to that property in South Carolina? It went to his spouse. Now
Mm.
she knew what his intentions were, right? And then when he asked about it, at first she said she was going to give it to us, but when she realized she had the house free and clear, she told me and my brother that she needs the money. She gonna decide to, she decides she's gonna sell it. So that's why I'm passionate about getting getting this will done for all of my clients, right? So there's some questions they have some people in the chat. Um, Hold on a second here.
I'm answering questions in the chat.
Oh, I see someone raise their hand. Was that No Cole? Raise their hand. Hold on a second. I will take No Cole off of mute. Okay. Anyone else raise their hand? I'll take you off mute and you can come to the stage.
Hello, can you hear me?
Yes.
Yes, we can hear
Oh,
you.
perfect. Um, I have a quick question. If, for instance, a will was certified or processed and no one knows about it, how can we find out about it?
That's very hard to do unless it is filed. Like certain states, like for instance, I do a lot of business in Texas. In Texas, if your will isn't notarized and on file and in the courthouse of your jurisdiction, if you're a business owner, the state of Texas can take your business from you. But it makes it so much easier that when somebody passes away, that the will is on file, so you can have access to it that way. So there'd be a court record of that will being on file. Now here in Jersey, we don't record wills. You have to keep your will in a safe place for someone to know where it is.
So in New York, does the Texas law also apply? Like it needs to be filed, or is the same as New Jersey? It has to be kept in a safe place.
I think it's at the discretion of the person. Our law firms do not keep the will. What they will do is they once it's sent to you and you have it notarized, and in New York, y'all are special, right? New York has to have an attorney notarize the will, right? And so that's the only state that I know that does that. So in terms of filing it, I believe you can file it, but that's on you to take it to the courthouse.
I know in New York, the attorney, they not only do they sign it, you have to do the signing in front of the attorney, but they also in New York, they also do keep a copy of the will for you in New York.
Oh, in New York they do? Okay, that's good to
Yes.
know. Because I know New Jersey they do not. After 7 years, it's gone.
Okay, thanks.
So there's a question
Awesome.
in the chat. Do you train new associates on what to present to consumers?
Absolutely. This is part of the training, right? So the main thing that I've been telling folks is that now you're doing life insurance. So that's a big asset. In addition to that, they probably have a house. What do you want to have happen with that? Are you prepared? So I have a questionnaire that I use, that I give to each of my insurance folks so that now that we've gotten your life insurance done, now we've done your financial planning, are you prepared? Right? Do you have a legal team protecting your family? Do you have a will, a love letter will package? Do you have a legal team protecting your small business? Are you a small business owner? And then it asks other questions about identity theft. So yes, I mean it's easy. All you have to do is get them to get the membership, and then we get them in front of a presentation like this, or do it on one-on-one.
And we have time for one more final question. Alonzo had his hand raised, so Alonzo, you can
Real
ask your
quick,
question.
in terms of the states that don't record, is there something that we can recommend, like outside of a safety deposit box? Don't go to the bank and keep it in a safety deposit box, though it is a good idea. But a digital asset. And to Charles's point and to your point, Eileen, before you answer my question, guys, we're doing fact finders. And literally in the fact finder, we ask, do you have a will? Do you have an attorney? So this is kind of like
It's
the
it's
next,
candy from a baby.
yeah.
And the answer is out of 9 times out of 10 is no.
Yep.
I say 11 times out of 10.
Exactly. You're right there, Alonzo. I'm 100% with you on that. Especially in our community, it's horrible. But the reason being is that one, we procrastinate because we feel that one, we're going to be priced out of it. And if we're not priced out of it, then it's like they have that superstition that if you get your will, you're going to die. Right. So that's why I wanted to simplify and demystify this process so that we can get folks to see what it is that we do and get it done. Because basically, what we call ourselves on my team is that we're the estate planning service for everyday families and small business owners, so they can leave a legacy instead of a mystery. And we simplify and demystify the process so we get it done. Bam. So in terms of to answer your question, Alonzo, like my will is in those old school strong boxes. So it's fireproof. So if the house goes up, they know where it is. I'm waiting for my next copy because we have a granddaughter who was just born 6 months ago, so we had to revise it. So we had our little Naomi in there. So yeah, and the cool thing too is that there's revision. So now that you are their trusted advisor, so like you have this now, but if something happens as life changes, you can do the revision as long as you have the preferred or the premium plan. So yeah, I would definitely be happy to, so we can get everybody trained up on this. So Dean is asking, what if you don't want the membership, but you want to do a love letter? Okay, well, you can do the love letter, but there's going to be a comma in that price tag. 12 years ago, I realized that folks weren't getting their wills done. So my component, I'm a Legal Shield associate, been one for 24 years. But when I go out into the public, I'm wills and more. I have platforms that are going to be able to assist folks in their estate planning needs. One of those platforms is Legal Shield. But I have others, there are folks that want to sit down in the office and pay thousands of dollars, and that's good. But to your question, if somebody does not get the legal plan, they're going to pay the regular price for a will, living will, healthcare power of attorney, financial power of attorney. Whereas if you do it through the service, it's just a matter of like, okay, it's a value add, and you're going to get your wills and so much more. So, I have folks that they paid for the year. I noted on my calendar because I don't have any other system other than I'm sure Charles probably has a great one, but I put it in my calendar when the will was done, and I put it in for 2 weeks before the year being up to reach out to them to see if there's any changes, any revisions they may need to have done. And if there are none, then we say, okay, well, do you want to keep it because you have property out of state? If they say no, we cancel, but they get to keep their estate planning documents. So you can get everything that's in the love letter, but you're going to pay. You're going to pay more than you really need to when you can get the wills and so much more through our legal shield plan.
All right, great. So thanks for that. So I guess Eileen, what do you suggest next? I mean, we have um we could reach out to everyone, I guess.
Okay. Well, if you put in the chat that you'd like to know more about how to offer this as a value add, please put more in the chat. And then we'll reach out to you, show you what that looks like, how that works, and how this could be a lovely additional income stream while you are helping your clients.
All right, good,
All right,
good,
awesome.
good.
I see more and more and more. I love it. All right, Prince Michael and Dina, and all right now, Linda. All right. Because we could schedule another Zoom and we'll take you through that whole process.
Awesome, awesome. All right. So with that said, thank you so much, Eileen. We really appreciate it.
My
Um,
pleasure.
I love hearing this, and I'm passionate about this, and just going around, like even doing just a annual review with the clients and doing the fact find. You have a will,
Yeah.
answers always no, and then they have horror stories in the family where they should have had, and like you said, it's because they feel like it's just too much money, and this breaks it down to where they can manage it and do it with an official law firm. So with that said, everyone, thank you, and enjoy the rest of your day, and I will be reaching out to you. I appreciate it.
Awesome.
All right, everyone.
I
Have a
have
good.
a blessed rest of the day. Thank you for your time and your attention. And let's show folks how to leave legacies instead of mysteries. All
That's
right,
right.
let's go.
Awesome. Thank you
All
so
right.
much.
Look
All
forward to
right.
meeting y'all soon.
All right. Bye bye.
Thanks for having me, Charles. Bye bye for now.